Amongst us today, we have Mr. Puneet Chaturvedi. He is a BCom and LLM graduate with specialization in corporate and commercial law. He has been a part of the renowned law firm S.C. Chaturvedi and Company and has had 9 associate law firms across India. His personal experiences include being a part of the Supreme Court of India for the last 25 years and in various high courts across India, apart from practicing at the Bombay High Court. He's written various legal articles and columns in magazines and websites. His teaching experiences include teaching LLM at the University Department of Law and LLB graduates at the GLC. He's taught law at nmims, JCCL and PGCL, apart from many law colleges in Mumbai. He's lectured in different law colleges across India and is a regular speaker on Constitution of India in the Bar Council of Maharashtra and Goa. He has conducted legal workshops in courts, jail, corporate houses, medical legal organizations, etc. Mr. Puneet's achievements include awarded as the Best Speaker Award at Interreta, Australia, and argued several public interest litigations. He's spoken at different medical forums on medical legal and addressed several other professional forums on law. Apart from law, Puneet sir is a Vedantic scholar giving discourses on the logical interpretations of the Vedantic principles in the present day relevance. Now, I would like to call upon Puneet sir to begin with today's session.
There is a maxim which is called ubi jus ibi remedium. Where there is a law, where there is a wrong, there must be a remedy. Now, there is a limitation of the statutory law because the statutes are created on the basis of human imagination. You have to envision a likelihood of an incident being happening which is not on the right spirit. So you have to constitute some provision to curtail that wrongdoing. And that is how, on the basis of that vision, a statute is created. But as is very commonly known, that reality is stranger than fiction. Sometimes the incidents occur which have no remedy in the statute. And that is where the courts of England developed the remedies on the basis of common sense, which popularly came to be known as common law. That in the absence of any statutory remedy, how could one decide and how a justice is to be dispensed? So the courts in England, unlike equity courts, started dispensing justice on the basis of common sense, which must appeal to the mind of people. And that is how common law was developed. Now, what is torts? Torts is basically, if you just find out the meaning of the word torts, because we don't have in day-to-day life the word torts. Its Latin meaning is twisted. Now, the law which deals with the twisted conduct of people is torts. And primarily, the remedies under torts are the judge-based, the courts-based remedies, not statutory based. Though statutes started recognizing those common law judgments and those remedies, and gradually those remedies came to be incorporated into the statutes, like Motor Vehicle Act. I'll come to that also. But very interesting aspect is that a man who has a right to vote is denied to vote by the returning officer. Now the person he intended to vote got elected. So whether he could vote or he could not vote, there was no difference in the result. But still he went to the court seeking damages, that my right is infringed. My right to vote got infringed. The courts came to the conclusion that though no damage has been caused by the deprivation of this right to vote, still he is entitled for compensation. And do you know why? Because of another maxim, damnum sine injuria sine damnum. If there is a breach of a right, it gives cause to the damages. Now, this was a leading case of Ashby versus White. Similarly, there's another wonderful case of 1805 by a common law court, Butterfield versus Forrester. You've heard of that? No. Now what happened is that a man who was renovating his house has to put some scaffolding across the wall for the renovation purpose. One of the poles of that scaffolding was on the mid of the road. Now the forester, who was the plaintiff, was coming from the other direction, riding on a horse at a very, very high speed. And despite seeing that pole, he could not control the horse and got injured. Now he claimed damages that due to this pole I got injured. The basis of the claim was the negligence by the defendant, that he had negligently put a pole on the mid of the road. Do you understand the ingredients of negligence? Duty to take care. That duty must be towards the plaintiff also. There is a breach of that duty. That breach has caused an accident, and that accident has caused and some injury. So these are the 5 factors of negligence. Now, this injury to the rider of the horse was denied on another principle, which is called contributory negligence. What is contributory negligence? It's one of the defense of negligence. Contributory negligence is one of the defense against negligence. That the person who's injured or the victim of some accident basically has added to the injury. It's his fault as well. There is a contribution to the fault, and therefore he is not entitled for the compensation. That is what is contributory negligence. So Butterfield versus Forrester, the ground of negligence fall flat because the courts say that you have also contributed due to your high speed riding. Despite watching that there is a pole, you could not control yourself. So you are negligent while riding a horse to such a high speed that you went and, despite seeing you, dashed to the pole. Now the contributory negligence is one of the defenses in Motor Vehicles Act also. When a pedestrian is hit by some speeding car, the victim is the pedestrian, who normally puts a claim against the injury. And we as a lawyer normally has the defense of contributory negligence, that why did he came to the road? He was not supposed to be there at that time when this accident happened. Because there are pavements to walk, there are overbridges to cross, or there is a zebra crossing. He has to wait till the signal is there. So he contributed to that negligence, and that is why the accident occurred. So this contributory negligence was invented in 1805 by the courts of England. Again, common law courts. Though it has been gradually cultivated by equity courts, and later on statutes have also recognized these aspects. But what I was about to tell you is that the concept of negligence, contributory negligence, and your professor, Ms. Aarti, had requested me to highlight Motor Vehicles Act in respect in conjunction with these tortious liabilities of contributory negligence and composite negligence. So we'll cover these aspects so that you can understand the statutory provisions of Motor Vehicles Act in respect in conjunction with these common law theories being developed over the years, over the centuries. Now, suppose a diver dives in a swimming pool and gets injured. And when he gets injured, he lodges a claim against the owner of that swimming pool. What if the swimming pool owner comes with a defense of contributory negligence on the ground that the diver did not take care to notice that which point is he diving? He was diving at the point which had a very shallow water. That's why he injured. So in case if the owner of the swimming pool had taken care of putting signboards of the depth of the swimming pool, then this contributory negligence defense will hold good in the court of law. But if those signboards are not there, then the negligence will hold good, because the owner of the swimming pool was negligent to to declare the depth of the pool at different places. That is how, on these minutes, the cases are fought, won or lost.